Columbia, I've seen your mountains high, seen your pretty rainbows and your blue crystal skies, watched your winding rivers as they flow around the bend. To me, you're not a stranger, you'll always be a friend.
Coming to you from the West Coast, this is Politicos. Today is June 20th, 2018, and this is episode 91. Politicos is the BC Politics Podcast. If you haven't already, make sure to subscribe and leave a review wherever you found us. Follow us on Facebook and Twitter, where we're at PoliticosPod, and support the show at patreon.com/politicos.
I'm Scott Delaneboom.
And I'm Ian Bushfield. On today's show, we talk to good friend of the show, Lindsay Tedds, about the MSP Task Force report, which it turns out was actually done for a while. Stay tuned for that and other shocking revelations from what might otherwise sound like a very dry subject. And I recorded a conversation earlier this week on the Trinity Western University decision with the pro-bono counsel for the BC Humanist Association, which I am the executive director of, and Michael Spratt from the Docket. So we'll put a bit of that in there. Patrons may have already listened to that on our Patreon, and the full discussion will be up on the BC Humanist podcast, just as a way to get that out there. But first, we have to thank our premier sponsors, who are, of course, Lindsay Tedds, who you'll hear from shortly, and Blake Hodson for helping make the show possible. And as always, Politicos is in partnership with BC Today, British Columbia's daily newsletter dedicated exclusively to BC politics. Sign up for your free 2-week trial to get unique coverage of the BC legislature delivered to your inbox every morning. Listeners, you use the special offer code CITIZEN to get a special rate just for you. For your free 2-week trial, go to britishcolumbiatoday.ca and enter that code CITIZEN in the referral code. First up, a taxing task force. Well, we just spoke to Lindsay Tedds, so let's throw it over to that. Welcome back to the podcast, Lindsay Tedds.
Thank you very much for having me.
We're welcoming you back after the MSP Task Force wrapped up its decisions and its consultations and its work and released a report late last week.
Yeah, released 2.5 months after we submitted it to the government, but, at least it got out.
So the report was actually done a while ago then?
Yeah, we had it wrapped up well before Easter. We met our deadline, and I don't quite know what drove the release of the report, but yeah, we were done in March.
So that was still after the BC government announced their plan for the MSP phase out and replacement. Why did the work continue on the task force after that?
Well, by the time they made that announcement, we only had 6 weeks left before our deadline to produce the final report. And we were actually fairly far along in working on knowledge and information and what the recommendations were. So for, if I can be an economist, for a marginal cost of letting the task force work for the last few weeks to produce the final report, they at least were able to get that knowledge and information that we had acquired and had already put pen to paper on at that point in time.
Well, and so the government, as we've talked about in the past, instead of taking a, broad approach as your interim report had suggested, decided to go through with this single payroll tax. Maybe just remind us of how that works and what maybe the concerns were that were sort of highlighted in the interim report that came out.
Yeah, so that payroll tax is a graduated tax that's levied on businesses according to how much they have in payroll. So if you have under $500,000 in payroll, you pay no tax, and then it's graduated above that. So if you have a payroll of $500,001, you immediately start paying the full tax. So one of the things that we're concerned about was, we were given very strict principles that were to guide our work. And one of the key principles we were given was business competitiveness. And we were very concerned about business competitiveness within the environment that we were working in. And of course, we have more knowledge now. We were concerned with the tax changes that were happening both at the provincial and federal levels. We were concerned with the U.S. tax reform. We were concerned with uncertainty over the business environment. And we were concerned with risks related to tariffs and trade. And of course, now some of that is we have more knowledge of, but business competitiveness was important, and it was stressed to us as being an important criteria to consider.
And why would the payroll tax affect business competitiveness?
What it ends up doing is how it unfolds depends on each of the businesses. So any business that has high-paid individuals that have bargaining power, more of that tax is going to fall on those employers. And the more that they absorb, then the less they're able to invest, the less they're able to hire, the less they're able to pay their employees. The trickle down can be throughout the economy. And these are things that you have to be considered as we are very much in an environment where growth is lower than we used to experience. So anything that sort of distorts the little bit of growth that we can get is concerning.
Well, maybe looking at your new report as a whole, what was the overall goal you were trying to achieve with each of the recommendations? Like I know you talked about a number of policy areas that you would want to try to address with these tax proposals. Maybe just run us through that.
Well, on the personal side of things, we were very concerned about affordability. And we were looking at measures that we could tweak. So now we're in the part, as we're working on our final report, we're looking at what are ways that we can tweak the tax system without raising any revenue, because we had no mandate to raise any more revenue. Mm-hmm. So, when you're doing tax reform and you can't raise revenues or spend any money, it's somewhat limited. So we put together, on the personal side of things, we put together a package that was designed particularly to ensure that low and middle income earners would see a bigger benefit from existing tax credits that we already have in the system. And it looked to modify the homeowner grant to really address what was coming out about concerns related to affordability. And I think so far in the headlines that I have seen, what we had recommended in terms of the reform of the homeowner grant into a more housing affordability, rent affordability, has really been lost, and it's very disappointing.
Is that suggesting the government's not taking these recommendations? And we'll get into the recommendations specifically, but they're not really looking into them?
Well, obviously the political environment has changed. In March, the reaction to the school tax and the property tax changes had not yet fully rolled out. So I can imagine, here we are now, any tweaks that this government does to property taxes, particularly that homeowner grant, is going to be viewed in a very different light.
The school tax only hits people significantly above where the homeowner's grant gets cut off. So is that a serious concern?
Well, I think it's just overall looking at property taxes in general. It's a hot button topic. And I don't think they wanted to, I don't know, right? Nobody talks to me. I don't quite know what's in their minds, because we, as a group on the task force, felt that the reforms that we are suggesting to that homeowner grant was actually going to be a game changer in the province related to affordability, because we were going to be delivering it on a regular monthly basis. It was going to be enriched for everyone, not just for seniors. So it was going to be based off of income. So it wouldn't matter if you were, 25 or 65. You could get a bigger benefit to help you with housing affordability. And we also included renters in it, because renters pay the property tax, particularly in markets that we're seeing in Vancouver and Victoria, where there's low vacancy and the property owners have all of the market power. So we wanted to make this more about property tax relief for everybody and not just for a certain segment of individuals.
So this changes to the homeowner's grant and this housing rebate forms kind of the core of your first recommendation, this Dogwood benefit. But you have a couple other proposals in there, specifically around non-alcoholic beverages and applying PST to them. And I think
Sure.
your writing or the report suggests this kind of came out of a desire for a sugary drinks and junk food tax. Maybe walk us through what the idea was there and why you didn't go down that road and apply to more, I guess, broad-based PST.
Sure. So one of the things that we heard extensively during our consultations and getting feedback was a surprising amount of individuals who wanted a health user fee. Those are, of course, contrary to the Canada Health Act, and there's other reasons why you wouldn't want a user fee so that somebody has to pay, say, $10 to go to the doctor or something like that. But the principle of it behind all of this was people saying people who have unhealthy behaviors should pay more towards our tax system. So this is what we were hearing before the government moved in the budget. And so we were actually looking at raising revenue through, tobacco taxes and liquor taxes and I don't even know what to call it, non-alcoholic beverages, except for water and unflavored milk. And we looked into the literature, and the literature here is quite clear. I mean, these taxes on unhealthy products don't necessarily move the needle much on obesity, but these products have absolutely no nutritional value, and they do impose a great health cost on health authorities. But we also wanted it to be administratively simple. A lot of sugar taxes are based on the amount of sugar that's in it. It exempts certain products. It does all of this kind of stuff. And it's very complex. So we wanted something simple. And we also wanted to make sure that we accounted for any preference changes. So, for example, over the last 10 years, people have reduced their consumption of soda pop, but they have increased their consumption on what I call sugar water, which is the vitamin water that comes out of Ontario, and the energy drinks. So you never want to be caught with a system that's always having to play catch up to changes in behavior. So we use what's already existing within the GSP system, which is non-carbonated water and unflavored milk are completely removed from that system, and everything else is either taxed or is zero rated. So we can use their definitions to apply to the CSP.
So kombucha would be taxed?
Yes, it would. Sorry, I've never had it.
Oh, no, sorry. What I was actually interested in was your Ministry of Finance estimates that this would raise actually $120 million a year, which is not a trivial amount of money.
It's not a trivial amount of money. Of course, that the Ministry of Finance is unable to do any behavioral change modeling. So that would be based off of no behavioral change. What we've seen coming out of other jurisdictions is there's a slight behavioral change, but these, and I've said this on Twitter a lot, taxing sugary drinks is a revenue generator. It's not about reducing obesity, but they are great revenue generators. They are, and they are very effective revenue measures.
Is that because people in general are just price insensitive when it comes to sugary drink, or is there a level at which you can tax it at that actually really does start to affect behavior and obesity levels?
Yes, but it's at a level that would be quite high. As we're having conversations about carbon taxes and talking about the difference between a $50 carbon tax and a $200 one. Yes, you can get to a point where these are unaffordable. But the thing is why you don't necessarily see much changes is that these drinks comprise a small portion of your budget. So if they go up by 7%, if you're already paying $1, now you're paying $1.07. A lot of people aren't going to be that sensitive on the margin. But if you really wanted to address obesity, whether or not you could make these high enough, I'm sure you could, but then you're getting into the inefficient part of a consumption tax.
So just to come back to the Dogwood benefit more broadly before we move on to some of the other recommendations, I guess the idea here is to create a simple one kind of tax credit, I guess. Is that correct? And what's the advantage of doing that?
Yeah, so within the system, we have the sales tax credit already. We have the BC Climate Action Tax Credit. We had this modification to the homeowner grant that we were recommending. Each one of these is separate and individual, and as a result, it's either only paid out annually or quarterly. But if you combine them, and this is what Ontario did with their Trillium benefit, was as soon as you can combine a multitude of different tax credits, it's now cost effective to deliver that money on a monthly basis. So that individuals, particularly those who are at the lower end of the income spectrum, are going to get more money more regularly to help them with affordability in the province of BC.
So did you steal the name Dogwood from Ontario because they use their provincial flower?
Yes.
Okay.
And,
I thought it was a good name.
Suitable. But... Yeah, we thought it was too.
Are there any other recommendations in this report that we haven't touched on yet that you'd like to discuss?
Yeah, so at the same time that we were working, you might remember, and this committee is still working, there was the Fair Wage Commission, and they issued a preliminary report. I think they wrote theirs in December, and it was released sometime in February or March. And they're still consulting 2 years about minimum wage. One of the things that the tax system has, so BC has this, Ontario has it, the Atlantic provinces has it, is a top-up to the basic exemption. So everybody can earn about $11,000, free of tax within the province. And increasing that basic exemption is quite costly because everybody benefits from it. So in order to get targeted tax relief to low-income workers, we have these tax reduction credits that are targeted towards a specific range of income. And what we were concerned about was as the minimum wage was increasing, and it was projected to increase at a fair clip in the province, minimum wage earners were going to be facing a fairly steep marginal tax rate because they would be phased out of the BC tax reduction credit. So we recommended that this BC tax reduction credit be geared to minimum wage and increase lockstep so that minimum wage earners aren't facing a fairly steep tax increase on additional income.
That seems
And we
reasonable.
thought that one was kind of neat. Yeah, we thought it was kind of neat. We thought it was important. And, if you had, levied a tax, say, on, sugary drinks, you would have some revenue to be able to do this. So from what I read of the press release from the government, this seems to be one that they are actually quite attracted to.
When I was reading it, it almost sounded like something that was just forgotten previously when we were looking at minimum wage increases. Like it's just a simple fix to help support people who make a little bit more money, and those are not the people under a progressive tax system that we're trying to punish, as it were.
With all of the tax credits that we have, and yes, I do realize that I'm recommending another one, it is easy for some of these to get lost. And we certainly found that not a lot of people knew about this feature in the tax system. We certainly learned through the Ontario election that even the now soon-to-be premier didn't even know about this one because Ontario has it as well. So, I think these things get introduced and then everybody forgets about them as important policy levers.
Can we talk for a second now, just to move a little bit further in the report, on about this section about PST reform? And what it looks like you're suggesting is not an HST, but try to get the best features of it without spending the political capital. Is that a fair characterization?
That is a very fair characterization. I mean, we were explicitly in our terms of reference, our original ones, we were explicitly told not to consider changes to the PST. But with our new mandate, that wasn't necessarily, I didn't see that in our new mandate at all. And we saw this as a quid pro quo to the payroll tax that was introduced. So there are ways that you can offset the decline in competitiveness through other tax reform. And a key way of doing that is actually through getting rid of the sales tax that we have in the province and move it towards a value added. Does it have to be an HST? Absolutely not. Kevin Milligan did a report for the big BC Business Council, the BC Business Council, and he devised 3 different ways that you can implement an You 3 different ways you can implement a value-added tax within the province without it being an HST.
Okay, and there's also some tax compliance initiatives in the report?
Yeah, so one of the things when we were working is we did want to look for areas that were, low-hanging fruit for tax revenue. But one of our key criteria was, of course, revenue stability. And so cracking down on tax compliance doesn't get you revenue stability. But if you're looking at reforming the tax system, as we were told to do in our second mandate, tax compliance initiatives then should be a key part of that. And, I think I've said this before on this podcast, Ontario and Quebec are provincial leaders in moving towards greater tax compliance. Most of the province sit back and say, hey, that's an area for CRA. That's not our responsibility. And we were trying to give this government ideas about how it can move forward on obtaining tax revenues. Like in Ontario, it's about $300 million that they're getting out of their underground economy initiative. You can get some pretty good revenues to pay for some of your promises by working conservatively and every year on different areas of tax compliance. So, for example, important areas that Quebec has cracked down on is suppression software that you can put in point of sales terminals that delete a certain amount of transactions from the record so that then the business owner can then skim out of the till. There's easy ways to reduce that kind of activity, and Quebec and Ontario have both moved in that area.
A couple of things you mentioned, or I saw in the report, were rules around home ownership, some of the new taxes coming in there, and this problematic beneficial ownership or increasing transparency in beneficial ownership. And I haven't looked closely at it, but the news today was that the province is working to try to make it clearer who owns.
Create a database.
They're creating a database of property owners in BC.
Yeah.
I was wondering if you had seen that and could sort of comment on that in this sort of framework of tax compliance.
Yeah, I read probably the executive summary, the page and a half of it. I fundamentally, and I've certainly said this before, I fundamentally don't understand why they're solely doing this for land-owning corporations when you can do it for everybody. We've seen through these releases from offshore jurisdictions that this issue of beneficial ownership and transparency of it is absolutely essential for tax compliance. So why is it just not all businesses? I don't understand that.
Fair. I guess the last bit of the report was on gender-based analysis, which is something I'm actually really pleased to see in there. It almost struck me that the mandate that was put there initially wouldn't have suggested you reach or sort of recommend a GBA approach. Maybe you could just touch on why you think that approach is important and why the province should adopt it more broadly.
Sure. Because this is certainly coming particularly from me. I've been watching this area unfold now for a few years, and the more I go into the research and see the difference it makes when we look at how policy affects different people differently, it makes for better policy, and it makes for policy that is more conducive to economic growth. So, for example, we know in the literature the labor supply elasticity of women is vastly more sensitive to wages and taxes than it is of men. And this is why we have to be very, very careful about how we structure our tax system, both on the basis of a household, but also related to progressivity, because women are more likely to be low-income, low-wage earners. And so tax systems that impose high taxes on lower income are problematic for assuring economic efficiency. So gender-based analysis, I know lots of people roll their eyes at it, but as an economist, we do this kind of analysis all the time. We don't call it GBA, but just understanding how people are different and how they can react to policy and what this means for equity, efficiency, all of those kinds of things is absolutely important. And I certainly, in our conversations with the Ministry of Finance, they didn't seem to be all that aware of what was going on in the field of GBA. And I've never seen anything in the BC budget or in any BC documents looking at gender-based analysis. Now, as we were working, there was the appointment of the parliamentary secretary for gender equity, but I haven't really seen much of what that individual is doing. And so we said, hey, if you've got this person, let's start working towards a comprehensive framework of how to design and deliver tax policy that's consistent with GBA principles, because GBA and tax policy have not gone hand in hand, and that might have to do with maybe the gender profile of most tax economists.
Well, it's actually surprising to hear that. I mean, this is a government that came in and talked about appointing a gender balanced cabinet and, like you said, appointed a parliamentary secretary of gender equity, but I guess it's more like show than actually doing the work so far. Not to like ask you to cast aspersions or anything, but just to sort of on the tax question specifically.
Well, yeah. See, what we see, and I'm watching a number of governments work on this, including here at the City of Calgary. When GBA is rolled out, it's always focused on social problems and social equity and social programs. And somehow the economic and finance and tax system gets completely ignored as we deliver on policy. And I want to see that change. And so that was my point in having this as part of the report, is that gender-based analysis is not just about social programs and equity. It's also about economic efficiency and ensuring that we have an economy that works for everybody and growth for everybody.
So you gave the government this report a couple months back, and they finally released it to the public last week. What's been the response from the government on it?
Well, I didn't know it was going to be released. I got a heads up about 30 minutes before it was going to be released. I'm not quite sure, what happened to that was the timing of it. They basically issued a report. I think Carol James may have done a press conference, but that is really all that's happened. There was certainly none of the conversations that happened all the way up to and after the interim report. So some people have already said that the report is being ignored. I have a feeling that within providing this government holds for another year or two, I think some of these might be looked at again.
Let's hope so. I think there's an appetite, or at least I've heard rumors there's an appetite in the government for further tax changes, although this last session has been pretty acrimonious over the ones they've made so far, justified or not. One thing I know you've talked about with us before frequently is the ideal of having a more comprehensive tax reform. Do you think that's still necessary, or is this report sort of just a first step on that road?
Well, yeah, because we were quite clear this is not comprehensive tax review or reform, because we were given a mandate that we worked with for 3 or 4 months. That was then changed in the last 3 weeks, and we just cobbled together a few of the ideas that we were working on. I would like to see a more concerted effort for comprehensive tax reform. Now, I don't know if you saw Kevin Milligan in the last Canadian Tax Journal put out a number of papers that talked about how we should proceed with comprehensive tax reform. And I do think that we need to ensure that the federal and provincial governments are working more concerted,ly and collectively on tax reform. Right now, they're almost battling against each other sometimes with their tax reform. But we also have to recognize different provinces are dealing with different issues. And so there has to be some appetite for changes therein. But I think, for example, if there was a better understanding between the government, the federal government, and say the BC government, maybe we would have seen a better way of approaching this capital gains taxation and housing that would not have led to, all these people driving Jaguars that live in Point Grey showing up all at a town hall together to say nasty things to people.
I mean, there's a certain amount of partisanship in BC that's almost inevitable, I think. So maybe you're right.
Oh, I don't know. But, I like to think at some point in time we are going to move to a system like they have in the United States, where there's a threshold of principal residence capital gains that are exempt from taxation, and then everything above that is taxable.
Was there anything else you wanted to touch on that we didn't get to?
It's funny talking about this report because we wrote it so long ago, and it's pretty amazing what you can't remember. But, I would suggest that people read it and think about it, because I actually do think that Dogwood benefit has a great deal of value. And if people would just get beyond the reaction of, oh my God, you're getting rid of the homeowner grant, to seeing a different way of delivering relief related to housing affordability, I think it has some value.
Okay, well, thank you for joining us.
Well, thank you very much for having me back.
Before you go, why don't you let our listeners know where they can find you?
Well, I am, of course, now at the School of Public Policy at the University of Calgary, and you can usually, although I've not been as active lately, you can find me on Twitter. The handle is @Lindsay Tedds.
All right. Thank you once again.
Thank you.
Great, thank you.
Moving on to segment 2, schools out for TWU. The Trinity Western decision came down this past Friday from the Supreme Court. You sat down with the BCHA's pro bono counsel and Michael Spratt at the Docket.
The conversation kind of speaks for itself. I obviously have a huge conflict of interest on this, as for work I was one of the interveners in the case, but I still thought it would be interesting to talk with the counsel we had who spoke there and Michael Spratt, because I thought initially it might go on his podcast, The Docket, but he's doing a special feature on the Staircase documentary on Netflix right now.
The what?
It's a true crime thing.
Okay.
It's like Making a Murderer, I guess. My wife's really into it. I guess I should probably watch it so I can keep up with The Docket. But anyway, he's not going to run this interview, so we're running it here. We mostly focus on the religious freedom aspects that were part of our submission, and so we didn't really get into, I think, the historic nature of parts of this case as it reflects the LGBTQ community. For one thing, this is actually the first time the Supreme Court of Canada has ever used the acronym LGBTQ in a decision, and they did so without even defining it. They just started talking about LGBTQ people. And I did fact check that through Canly by Googling it, as it were. Let's just throw it over to the discussion, and the full conversation is up on our Patreon, and I'll have a cut up on the BC Humanist Association podcast, which you can find on SoundCloud or just by Googling it. On the line, we have Michael Spratt from the Docket podcast in Ottawa, and I'm sitting here in the temporary offices of Wes McMillan. Wes, you are the counsel for the BC Humanist Association in the Trinity Western University case, and we just found out the result on that on Friday.
Yes, we did. It was a good Friday.
So I'm the executive director of the BC Humanist Association, so we wanted to intervene in this case following the BC Court of Appeal loss. We went to Ottawa and we argued along the lines that Trinity Western is a bricks and mortar building and legal institution. It doesn't have feelings, it doesn't have a religion, and therefore it can't have religious rights. Did they like our arguments?
Well, there are a total of 4 written decisions. The majority didn't engage with it. McLaughlin, who wrote concurring reasons, wrote reasons that are more very sort of academic as to the process of weighing and these sorts of things, and didn't really go there. Justice Rowe did. He accepted our submission and other interveners as well. We are not the only one that made this point, but that these organizations, institutions, legal constructs don't have a freedom of religion in their own right. So he's the only one of the 9 that directly engaged. And of course, then two dissented, as I read their decision, largely on the basis of what the Law Society was entitled to consider, and saying, their legislation says you consider academic qualifications and that's it, and admissions policies are not your concern.
And so the majority decision was focused more around the harm done to the LGBTQ community, it seemed like to me.
Yeah, what the majority decision sort of addressed the issue in a way of saying, well, we don't have to address the issue of whether Trinity Western has a freedom of religion right, but the TWU community does, which I find that a rather unsatisfying thing, because there's no litigant known as the TWU community. The TWU community, by TWU's own evidence, is not homogenous. And it struck me as if organizations don't have the right, they're just going to rely on that decision to say, well, there's some community we represent. And maybe that doesn't work for a Hobby Lobby type situation where it's a private for-profit corporation. But you can imagine lots and lots of litigants coming forward, be they, nonprofit societies, things like that, just asserting that there's some amorphous, ill-defined community and therefore they're in the door on freedom of religion. So that's an issue I think needs to be sorted out, which is why I found Justice Rowe's decision at least satisfying, and he actually dealt with it.
Yeah, I mean, I think it's a very interesting decision, and I come from this as, a criminal lawyer who is engaged in litigation and often engaged with litigation that touches on charter rights. So I'm by no means an expert on these sorts of reviews, but it's a decision that I found slightly unsatisfying. It's one of those decisions where I agree with the outcome on principle, but the legal route to get there is pretty messy. And, I think that there are, some concerns raised in the dissent that have sort of been picked up in the academic community that, might lead us back to this court at some point on other cases as well.
That would be around this idea of administrative review and the approach on there.
Yeah, because I mean, what the majority says, and I'll just say majority and dissent, even though that we have majority and then some concurring decisions in the dissent, is, I mean, I think they very fairly and accurately define what law societies do, and how that they're public actors with an overreaching interest in protecting values and fostering equality and human rights. I think that they do a good job of, characterizing the public interest in having a diverse bar. But then when we actually get into the weeds of what the standard of review is, it's there I find some of the reasoning in the majority's analysis a little unsettling, because what we're really looking at, especially in the case of the BC Law Society that took its position sort of by referendum of its members, we're looking at a review on a reasonableness standard. So not necessarily it's the correct decision, but it's within a spectrum of decisions that's reasonable. We're looking at a review of that reasonableness standard, but you have to ask, what are you actually reviewing? And in the BC case, it's a thumbs up or a thumbs down based on a referendum with no written reasons and no other features that as a criminal lawyer I normally see in court that make sure that decisions are reviewable and most importantly transparent. So that's where it was a bit unsettling. And then in the dissent, there I think are some very good intellectual points about the difference between charter rights and charter values and looking at some of those issues. But I mean, ultimately, it's a decision that I welcome as someone who is regulated by these bodies, as someone who believes in those principles of diversity. But it's I think a decision that's not totally immune from criticism.
Well, McLaughlin and Rowe both, I think, touched in different ways on that same question of charter values versus charter rights and how lower tribunals should affect this. And I've heard this concern from other corners in the human rights civil liberties sphere of just this could let bodies that don't really have the expertise to handle these questions make what might be a reasonable decision, but it's hard to test their work.
In this case, I found that Justice Rowe dealt with it squarely, as did the dissent, saying this charter values, charter rights, that's a problem. These charter values are sort of ill-defined. Rowe says it's fine for charter values to sort of inform the development of the common law, but we don't elevate it to a charter right. Because in this case, someone could criticize the decision for saying, well, you found that a charter right was violated, and you found that violation was acceptable because of some competing charter value. That's a bit unsettling. So I have a problem with that. I appreciated Justice Rowe's approach. I appreciate the dissent's approach on that. And then on the administrative side, in this case, it's maybe easy for them to decide the case on a reasonableness standard because it really was a binary decision. It's a yes or no, not it's not as if the Law Society had a number of options. They did actually, and it's in the evidence, asked TWU, would you make this covenant non-mandatory, voluntary? And TWU said no. So it really was a binary decision. And they essentially said, well, it's reasonable to have said no, but would it have been reasonable to have said yes? I mean, these are charter rights and theoretically at play here. I mean, we can debate whether TWU in fact has a charter right and who does in this case have a charter right. But I share Michael's concern. That seems a bit. It's a bit too fuzzy in its logic, and I like the outcome too. But what sort of guidance are we giving to lower courts and tribunals in making these decisions in the future? Not being lawyers, but someone else. I mean, in this case, part of the majority's reasoning seemed to be, well, lawyers are special.
Lawyers are much smarter than everyone else, right?
I'm not sure why we're special in that way, because we're not concerned about lawyers. We're concerned about people whose rights are being violated. We're concerned about LGBTQ people and their participation in society, whether they choose to participate by going to law school in some other way. I wouldn't have thought going to law school makes them more special and more deserving of some protection, but there you have it.
So one of the things I found interesting in the majority here, when you talked about the balancing, they, even just in the quick header, talk about this decision by the Law Society not limiting religious freedom to a significant extent, and they talk about how the mandatory covenant isn't absolutely required to study law in a Christian environment. But on the flip side, the closing down options to the LGBTQ community creates this actual harm there. And it seems like they've balanced the scales found that the balance of the scales is in such a way that the only reasonable decision, and they don't come quite out and say the only reasonable decision is this. Well, but on a quick reading of it, it kind of felt that way.
Well, this is where I go back to my point. I'm interested in what Michael thinks on it too, but my point about it really being a binary decision. So they didn't have to wrestle with that. I mean, if the Law Society really did have sort of a panoply of remedial options there, a reasonableness standard seems to become a bit more difficult. I don't know. Maybe it's. Did they end up coming down and saying no? The only thing that was reasonable was to say no. We're not approving you. So that's where the limit of sort of options available to the Law Society, I think, makes the analysis on standard of review less robust, because it doesn't need to be. There's only two options.
Yeah, I think that was sort of a special feature in this case and made the court's decision easier. We also, I think, need to look at how this sort of administrative body might be different from other administrative bodies that come before the courts. Because, I mean, one of the things that the court mentions in this case is that, benchers are elected, they're accountable. And that's not true of all administrative bodies. So when we are dealing with law societies, they're different than maybe some of the other places where this decision could have some import. And I think that also made the Law Society or the Supreme Court's decision a little easier. And the material filed by TWU, I mean, when we're looking at the affidavits that were filed on behalf of students who wanted to go there, of course, those affidavits have to be true, but I wonder how much care was taken in finding the best representative individuals to submit those affidavits, because the court, I think quite rightly, pointed to some of those affidavits and said that, these students who want to go to TWU say it's a preference. It's something that they would have considered. It's something that they would have liked to have the opportunity to consider along other law schools. And so the court, it was a quite easy decision, I think, for them to find that when you're looking at, core religious beliefs and, the protection that religion has under the charter, that this covenant wasn't a necessary or wasn't necessarily something that had to be there for individuals who are evangelical Christians to actually receive a legal education.
That's certainly what I thought Justice Rowe dealt with it the most head on. I'm looking for the quote, but he sort of summarizes how the majority deals with it and says, I wonder if that hits the mark. I think the takeaway from this is that insofar as you have a religious preference, to the extent that preference causes, an ill effect, a harmful effect on some other group within society, that other group's going to trump. And that did seem to be a real feature of all their writings, for the those who ruled in favor of the law societies, was that this was fundamentally a preference. So I think that's sort of a feature to take away from this case is the notion that religious preferences just aren't going to be given the protection that those on the TWU side would have hoped for.
Well, because up until now, the definition of religion in a sort of two-way claim in Canadian jurisprudence is the Amselem test, I believe. Is it a sincerely held belief? And well, what does that mean? It means you pretty much say it's sincerely held. And here it starts to look a little bit more about maybe what is that sincerity? How does that take effect? And what effect does it have on other people? What I sort of said to a group the other day was religious freedom in Canada is kind of like the freedom now to swing your arms. And you have that freedom until that arm connects with someone else's face.
Yeah. This is where I have a problem with the way the majority says, well, there's a TWU community. Even Justice Rowe says TWU doesn't have a freedom of religion, but he deals with what he calls the claimants, which is, he says, the individual claimants in this appeal. Mr. Volkanant, who is the individual who said he would have liked to have gone, and this says, and other members of the evangelical Christian community at TWU, which they're not litigants. There's nobody else there named as a litigant. So I have a problem with this, because what if just one of those people brings the claim? They actually get named as a party, as they ought to be. And they swear an affidavit saying, I sincerely believe this, and I believe it's a requirement of my religion that I only attend school with people of the same religious faith or are who prepared to conduct themselves as if they have the same religious faith. Does that then glom on to TWU, and TWU gets to say, there we go, now we have it? Because that seems to be the logical flow through of saying, in this case, well, we're gonna find a breach, as the majority does, of the TWU community's 2A rights. Mm-hmm. They're not homogenous. They're not a monolith. So I don't know where that particular aspect of this case that I find most troubling leads us in the future.
That's what you were pointing out in our factum when you talked about the religious oligarchy of the board of directors essentially deciding what the TWU community believes. But I guess that specific claim had more to deal with why TWU is an institution. The religious rights there don't really make sense. But
that was to say why an organization can't have the right, because it's not a monolith.
But we've still sort of treated something as, it's sort of a representative, almost human rights complaint type thing, where you're saying Braden Volkanant represents all evangelicals at TWU.
But that sort of claim is easier to make when you say it's because of a person's race. Because you are or you aren't, right? Whereas the religion is, well, you are, but you define it differently. So someone who says, geez, I'd like to go to TWU, that'd be my preference, is not infringed. Whereas someone who professes to be of the same religious faith says, no, my take on it is I have to. And I can't go to school anywhere else. So religion on the human rights and in the charter rights world, to me, has always been sort of rather different than all of the other rights. All of the other rights are really experienced as negative rights. Just don't treat me differently because, right? Well, religion has more of a positive aspect to it. It's not merely don't treat me differently. It's allow me to do these things, allow me to practice my religion.
What do you think on that, Michael?
Well, I mean, I think that it's when you're looking at the sincerity of the belief and how that factors into the case. I mean, I'm sort of in agreement with McLaughlin, who wrote a concurring opinion when she, calls out the majority a little bit about their comments on it, because the majority seems to accept its sincerely held belief, but they also accept that the covenant isn't absolutely required for the religious practice at issue. And she says, I mean, on one hand, the majority acknowledges that this is a deep sincerity in the belief, but on the other hand, they sort of cast doubt on the insignificance of that sincerity. So I think that there's always going to be a tension there. And that might just be a factor of how we look at religion, because at the end of the day, religion, although it's in the charter, these are, simply made up beliefs and not necessarily inalienable rights that people have. When you look at the right to life, liberty, and security of the person, that's very different than looking at, beliefs that flow from a text that was written thousands of years ago that, aren't necessarily at the core value of humanity or universal. So, I think that tension is going to be there. And at the end of the day, my real problem might be with the charter protection that guarantees or that puts, religious freedom on the same level as other grounds. But, that is, I acknowledge, a radical belief and not one that has any foundation in our current law, given how the charter is written.
I don't think it's radical. I don't think Ian does either.
Michael Spratt taking a radical position is not really radical in and of itself.
Yeah,
but
well, but that is a fundament. That goes to the philosophy of this entire thing. Is all the other rights seem to be something that no one has much of a choice over. They don't change over time. They don't evolve. Race is your race. You're born that way. That's what you are. But you're quite right. It has no founding in our law, so we have to wrestle with it. But this is where I'm going to sound like a broken record, but I harp on the point about saying, finding the organization doesn't have the right or refusing to decide about dealing with a community, or as Justice Rowe does, the claimants, solves none of the problems. And it's solved in this case because the court says, well, this doesn't seem to be all that important. But that doesn't solve the problem at all of what you do with the protection of the communal aspect of freedom of religion when you don't have a homogenous community and their particular take or nuance on the beliefs or practices required by that religion.
Well, the other thing that's interesting in this case is this is the final decision with Beverly McLaughlin's name on it. And it comes out as a pretty split decision, 4 ways with some clear divides, not just on sort of between the dissent and the majority, but even among the people who agreed on these admin law questions.
Bit of a whimper.
Do we wonder if the future of the internal Supreme Court, one of the things of Beverly McLaughlin's time as Chief Justice was she managed to get the court together most of the time, agreeing on things, or at least not sort of splintering into 8-way decisions where you can't really tell what the law is. Do you think Wagner's going to be able to keep the court together, or is this a sign that the future is confusing?
I think that we might be seeing more of these sort of split decisions, concurring decisions, 3-3, 2-1 decisions. And that might not be a factor of the new Chief Justice, of Justice Wagner, but it might be sort of indicative of who else is on the court. Justice Rowe has issued a number of short, sometimes odd concurring decisions or concurring dissents. And I think Cote is aiming for, the record for the most dissents, including in leave applications. She has dissented, I think, more than I've seen lately. So it might not be, there might not be anything that the new Chief Justice can actually do about it.
I agree. I think Brown is certainly unafraid to go his own way. And Cote, when she spoke here in Vancouver, I don't know, maybe over a year ago, I can't remember, but she was still relatively new and gave some speech to some lawyers. I can't even remember what about. But she said that she showed up and she sort of called herself the troublemaker. And she also did say that she thought they should allow more leaves. So I agree with Michael. It's probably a function of who's on the bench right now. And from a understanding the law perspective, unanimous decisions are helpful, but it's not always better. Right? If you have these dissents, you have concurring reasons, it sort of leaves an opportunity for courts to take another look at an issue with a different fact pattern. Because one of the issues in law is, these issues are decided on a fact pattern, and that's the value interveners come and say, it's not just this fact pattern, but at the end of the day, it's a singular fact pattern on which important issues can be decided. So sort of leaving the door slightly ajar to reconsider it on a different fact pattern may not be good for the certainty of the law, but it may be good for ultimately getting it right.
Any concluding thoughts, Michael? Anything we didn't touch on that you'd want to add in there?
We just need some rule about no matter how many concurring or dissenting opinions, we just need to give them a page length. The Supreme Court gives all of us a page length to even argue the most complicated appeals. I'm done with reading 200-page cases. I think we might see more of that if people go different ways. Let's go back to the 1970s, where you have these seminal cases on important issues that are delivered in, 5 pages.
They did deliver the BCTF decision a year back in like 15 minutes and just orally. So maybe that's what you want them to just say.
Exactly.
We side with, the BC Supreme Court.
We need better written appeal judgments so the court can just say, I agree.
Any final thoughts, Wes? And want to give a plug to your new firm?
Yeah, it's not Wes McMillan's new temporary space. It's Alan McMillan Litigation Counsel. We've been open for a whopping 18 days. Yeah, that's it. 1550, 1185 West Georgia. Come on down.
All right. Well, thanks for having me in here, and thanks for joining on the line, Michael Spratt.
Thank you.
Perfect. Nice talking to you, Ian.
Well, moving on to quick takes. There's a couple big announcements out of the BC government this week, because even though the legislature isn't sitting, apparently the government wants to do a lot more things. First up, there was an interesting announcement of funding for Indigenous housing. Specifically, the government has announced this Building BC Indigenous Housing Fund, where they're going to invest $550 million over 10 years to build and operate 1,750 new units of social housing for projects on and off reserve.
So what I heard is the most interesting part of this is that it's the provincial government doing it, which is very unusual because for the most part, pretty much all First Nations policy falls to the federal government.
I think this is part of the BC government saying no one's been stepping up on this.
Yes, fill in a void.
John Horgan has talked about the importance of reconciliation, and he ran on that. And as we'll get to when we talk about salmon next, this is somewhere where he thinks, it's better that someone does it than nothing. Even speaking of the Supreme Court of Canada, they ruled a couple years ago now, I think, on a case called Jordan, which implemented this thing called Jordan's Principle, which is the idea that someone needs to step up and fund Indigenous services. And if it's not happening, whoever can do it quickest can fund it and then sort out later who owes who money. I don't think the federal government's going to step back in and give us back the $550 million we owe for doing their job for them. But it's that idea of let's just do what needs to be done, fill the void, and make sure there are houses for people. The other provincial story to come up this week was around fish and salmon. This has been something the Green Party has been on about, and Adam Olsen specifically, and I'm hoping to get him on the podcast in the next couple of weeks to really do just a full fishy episode, because I don't think either of us are experts on this at all or have followed it very much. But there have been huge concerns over the wild salmon stocks in the province and the practice of fish farming in these nets in the ocean. The idea being when you have a closed net of a bunch of fish being farmed, they can pass diseases like all farm animals do, and those can get into the wild salmon stocks and then threaten them. And there's other environmental risks. And these are sort of ongoing and long systemic issues that people, environmentalists and First Nations groups have been really concerned about. So this past week, the provincial government announced a Wild Salmon Advisory Council that's going to look at the issue of wild salmon. What are the stock numbers? How can we make sure the populations aren't continuing to drop off because we might lose our salmon? And try to get a report back to the Premier by the end of the summer. This is pretty well received by most people. Adam Olsen himself is on there, along with a couple other MLAs. Although some Indigenous groups and advocates did express concern, as would usually happen when they say too many industry representatives are on there, not enough salmon advocates are on there. And perhaps a more landing criticism is that it's a council being set up within essentially the Premier's office. So it's a bit subject to partisan whims rather than something that's arm's length and can be a bit more free in its recommendations. But it'll be interesting to see where that goes over the summer. The other announcement, and this came just today after leaks came out yesterday, is around this issue of these fish farms that are all along the West Coast. And the BC NDP ran on a platform of UNDRIP and reconciliation and requiring Indigenous consent. And what they announced today is that all fish farms in this province are going to need agreements with local First Nations if they want to continue operating after 2022. So it gives them 4 years, if they haven't already, to put in place these agreements and get that Indigenous First Nation consent. The BC Liberals are saying this is like a veto over fish farms, but to some extent, it's almost how you have to treat unceded territory. To their credit, the BC Salmon Farmers Association says that over 75% of the salmon produced by its members are already in partnerships with First Nations. So it's not possibly a huge number that actually need to step up and meet this requirement. I did see a number of Indigenous groups criticizing this as 4 more years of sort of not living up to UNDRIP. But I guess the goal there is to just give time to build these agreements.
Yeah, and it's hard to phase something in like this immediately without causing problems as well. So 4 years seems like a reasonable time to be able to hammer out a deal.
The big reason for pushing this through today was today specifically 20 farms had their leases expire. And the worry was the NDP was just going to shut them down today or say they don't get their leases renewed. And there's expected to be 5 more have their leases expire by 2022. And what happens to all of those in the meantime is they're now on a month-by-month lease until either, I guess, they establish a agreement with the First Nations group or they lose their lease in 2022, assuming, I guess, the NDP is still in government. But like I said, we'll try to get Adam Olsen or someone else from the either fish advocacy or the fish farm, and someone who knows about fish to talk to us about this, because it is one of those most important industries in this province.
Well, moving on, the Chief Electoral Officer of BC has weighed in on the referendum questions for the electoral reform referendum and released, I believe it was a 2-page letter that more or less said, yeah, these aren't bad, but maybe we could tweak the words a little bit here and there, replace elections to the Legislative Assembly with provincial elections and a few things that simplify it and make the wording and use of acronyms a little more consistent across the wording of the referendum, but overall more or less gave a stamp of approval to it to the limited extent that his office was empowered to do so.
Yeah, he didn't have the ability to say whether 2 questions is better than 1 or vice versa. And I think a lot of critics of the referendum want to see first past the post versus a specific or even just a ranked ballot of all the systems. But, his office was tasked with making sure this is a clear, understandable question for people of all English language abilities and otherwise. And, the questions look moderately more clear. So credit to Anton Bojman for his work on that. I think there are still criticisms of the process out there that are pretty legitimate in that the NDP is still moving a bit slowly on rolling out all of the rules and what the financing things. They have said they're adopting the Attorney General's report on this, but that still leaves some latitude. And hopefully those come up quick because the campaign's supposed to start on July 1st, officially. But speaking of campaigns, there was a by-election in Quebec that I totally didn't know about until like 2 days ago, and it was held yesterday, I believe. And the Conservatives even won it. This was in the Quebec riding of Chicoutimi-Lafjord, and it followed the Liberal MP Dennis Lemieux resigning earlier this year for family reasons. And the riding had traditionally been very Liberal, except in 2011 when the NDP swept it in their wave. And it was a very close race that the Liberals picked up in 2015. But it didn't end up being close at all.
No, the Conservatives actually won an outright majority of the vote in this case. And the NDP, over the course of 2 elections, has dropped from 37 to just under 9%. So things are clearly changing in the riding.
Yeah, the new Conservative MP is Richard Martel. He got 53% of the vote, and the Liberals took about 30% of the vote. The other interesting thing is the Bloc was completely decimated in this election again. They got not even 6% of the vote, with the rest of the votes going to the Greens. Martel, I guess, or I gleaned from some CBC coverage, was very critical of the government's moves and approach on legalizing marijuana. He criticized the spending, out of control budgets and spending of the Liberals, And he was also highly critical of the Bloc Québécois for not standing up effectively for Quebec. And I think he actually got a couple high-profile former Bloc Québécois members endorsing him, which kind of suggests that Scheer's strategy, which has been talked about a couple places for Quebec of, I guess, leaning into that Quebec as a distinct nation approach that Harper took, is working.
Yeah, it's always difficult to read the tea leaves from a single by-election, but it does seem like the Conservatives are making inroads into Quebec, and the Harper-era conservative troubles in the province might be a thing of the past.
Well, and like you said, the other thing to pull from this by-election is that the NDP did not do well. Like, this is a seat they have held recently, and if Jagmeet Singh's path to 24 Sussex runs through Quebec, he's going to need ridings like this back in his pocket. And to go and lose 20 to 30% of the vote is rough. And all three leaders did actually campaign in this riding, as far as I know. So it's not like they just wrote it off and went, yeah, we're focusing on a future election rather than a by-election.
So yeah, it's increasingly looking like the orange wave has in fact crested and broken at this point, and Quebec will not be going NDP again anytime soon.
But maybe he'll pick up BC, and we'll have to see.
Moving on, the cannabis legalization has officially passed Parliament, and we now know that weed will be legal as of October 17th.
October 17th isn't July 1st, is it?
No, of course, with only a few days left between now and then, that was going to be a very tight timeline, and the Senate has taken their sweet time with this piece of legislation. Some good, because of some of the changes around the impaired driving stuff that they'd recommend, and yeah, some of it was a little more feet dragging.
Well, so the impaired driving bill is Bill C-46, and that is still in the process of being finalized, but by the time you listen to this may have been passed, because I think Parliament's trying to wrap up by Friday. What was passed, I think, yesterday and officially ratified with the announcement today was Bill C-45, which decriminalizes and creates a legal regime for cannabis. That passed the Senate after the Senate had sent it with 46 amendments back to the House of Commons. The Liberals rejected 13 of those and then sent it back to the Senate. And some of the ones that the Senate had recommended that the Liberal MPs didn't want included the provinces who wanted the right to ban home cultivation and a ban on distributing pot merchandise, essentially. So the Senate really didn't want you like wearing, I don't know, Philip Morris weed hat or whoever ends up being the companies that sell this. It is interesting to see this is sort of the second, at least high-profile time since the change in how the Senate works, that we've seen the Senate recommend a whole bunch of changes to the Parliament or to the House of Commons, and the House of Commons goes no, or at least the Liberals do, and then the Senate kind of just rolls over. And depending on how C-46 goes, they may hold their ground more. But right now it seems like the precedent they're trying to set is we try once, but the elected people win. And we don't have that written down, but I know in the UK they actually have it written down that the House of Lords can't, something like the House of Lords can't defeat legislation, but they can delay it indefinitely.
It's like a very fine procedural distinction right there.
But it's one that matters, though, because there is a sort of justification. We have seen the Senate actually defeat legislation in the past. But it's interesting to see the ongoing evolution of the Senate, and overall, I think cannabis legalization and the end of the prohibition regime is good news, even though there are some asterisks around the edges, like the government has still not said whether they're going to grant amnesty for people charged under the current regime, even though they're saying it should be legal, at least until it is legal. Then they might revisit it, which is a very weird position to take.
Yeah, it's odd. And something else that was struck me as a little weird is why October 17th?
I think it's a reflection of the concern by the provinces to have enough time to open stores and get all of those things. I think all of the provinces by now have their regime, their bills
more or less finalized. But yeah, it just seemed like a weird day. Like it's a Wednesday, kind of a couple months away from now. And, you know, if they'd waited 2 more days, they could do a nice symbolic, hey, it's the 3-year anniversary of us being elected. Look at this big promise we delivered on.
Maybe they specifically didn't want to tie it to their election anniversary. I
I
don't
don't know.
know.
It's a weird thing to miss that little symbolic thing by just 2 days.
They want everyone to have bought it in advance. Anyway, it's going to be a green Halloween here in Vancouver, in any case. Finally, let's talk about the US. It's a shitty place. The news this week has been about how the Trump administration has been all gung-ho to separate immigrant refugee children from their parents and put them in concentration camps because this is normal. Luckily, everyone came out in condemnation of this, and I don't think we need to dwell on it too long.
Yeah, the stuff that's been coming out about this has been pretty horrible, but I think there's been a fairly universal condemnation, although Trudeau did kind of walk a finer line than many Canadians were wanting of him.
Well, people were calling on him once again to repeal the Safe Third Country Agreement, which he hasn't done. The latest news is that this afternoon, just before we start recording, Trump did sign an executive order ending the policy of child separation, but it is still maintaining this zero tolerance approach to immigration crimes or something. So essentially, families are going to be kept together in concentration camps, and maybe I shouldn't call it that. Fuck it. He's evil. And he has also said he's not giving the kids back to their parents.
Yeah, so this, I haven't read the text of the EO yet, but from what I gather, it mostly applies going forward rather than towards the people they already have incarcerated. And
it's awful.
Yeah, it's kind of a little hard to find the words on this one.
It's somewhat fitting then that part of the other news that came out was that the US is quitting the United Nations Human Rights Committee. They're saying it's about anti-Israel bias or something, and honestly, there's lots of criticisms you can level against the Human Rights Committee for having countries like Saudi Arabia on it at times.
It's definitely a flawed institution, to say the very least.
But like, still, walking away from it is a sort of big flag of you really don't care. Like the whole thing's a joke at this point. But they're going to make a Space Force. Yeah,
that's the other thing that came out this week is another executive order dropped by Trump was that they are in fact going to create another branch of the U.S. military, because, don't know if they don't have enough of those already, and have a Space Force.
That was good for memes for like a day.
It got like at least a couple days memes out of it, and so in theory, all like the Air Force stuff and like any other branch that even tangentially touched on space will be shuffled off into this new Space Force. But like it seems like a really odd thing, and this isn't the first time Trump's talked about it.
Well, it's not like he cares, but there are international agreements that the U.S. is party to that say they will not militarize space.
Yeah.
And nothing says we're militarizing space like Space Force.
Yeah. And while they don't have weapons up there, like there is already a military component to space from all the various satellite stuff, and a bunch of countries, including the U.S., have anti-satellite capabilities. So like there is already a military element to space, but it's not exactly clear what this adds to that or changes.
More memes.
Yes.
To distract us from children crying in jail.
And yet another layer of Pentagon bureaucracy.
This is why we don't talk about U.S. news.
Yeah, it's just depressing most of the time, but just really it's been, a hell of a week in American politics.
One thing that it has been not good for, but one thing that it has given opportunity for is for the media to talk about all the different times that Canada has taken kids away from their parents. Somewhat controversially, doesn't seem like the appropriate word, but like wrongly, the 60s scoop and ongoing issues with child poverty and so forth. But yeah, everything is fucked. I think that's a good time to end the show.
And that has been Plato's. Find links to the stories we mentioned in the show notes. Make sure to subscribe wherever you listen to podcasts, and follow us on Facebook and Twitter @Plato'sPod. Give us a review and let us know what you think. Support the show and get early access to our interviews at patreon.com/Plato's. And if you have ideas for the show, feel free to send them to us. Thanks for listening.